So very good morning to all. In our class at present is Harshit Kumawat, Kartikeyan Sharma, Parth Narendra Bhai, Prakash Chaudhary, Pushpendra Pal, Rakesh Raika, Shaurya Dikshit. So let's start the class. So yesterday we studied about the presentment and the other things regarding your negotiable instruments. Okay. So today and onwards we will be studying about the dishonor of bills of exchange. Okay, so dishonor of bills of exchange we will be going to study today and onwards. So what do you mean by dishonor? Any one of you? Meanwhile, others will also join. Yeah, come on. Anyone? What is the meaning of dishonor?
Sir, dishonor or dishonor?
Dishonor, whatever. Some people say this dishonor. Is there any difference? Karthik?
सर डिसऑनर फिर वो हो जाएगा ना सर जो ओन नहीं करता कुछ और डिसऑनर वो हो जाता है जिसमें मतलब इट्स लाइक अ पर्सन इज नॉट having any kind of respect or anything, like he has been not been honored in
Okay.
anywhere now.
There may be some problem in pronunciation. Dishonor, right?
Yes sir.
Okay. So what is dishonor of the instrument? Come on.
So dishonor means, example, when your check gets bounced or when your inability to pay the amount. If you're not able to pay the amount, example, your check gets bounced, so that is the dishonor of the check. So that is insufficiency of paying the amount is called as dishonor.
Dishonor happens just because of you are not able to pay the amount, or it happens because of something else also?
There are other scenarios also, but one scenario is when you're insufficient to pay the amount.
Okay. Fine.
Like when you refuse to accept.
Yeah, please carry on. Yeah, you want to say something? Sure.
So like when you refuse to accept or pay a promissory note or anything like that.
Yeah, even when you refuse to accept it, that is also meant to dishonor. Okay. Fine. So, anyways, so let us just actually cover the portion which was left out yesterday. Some portion was left out, 2-3 slides regarding the endorsement, the types of the endorsement which we were studying. We will start with that, okay, and then we will proceed further with the dishonor. So if you see the endorsement of the instrument, we have studied about that yesterday, that when the maker or a holder of the instrument signs the same for the purpose of negotiation, on the back or the face of it, or a slip paper which is annexed to it, and signs it for some purpose, or you can say stamp it, okay, and deliver it to someone else. So that is called endorsement, and the person will be called endorser, and to whom it is endorsed, it's called endorsee. For example, X, who is a holder of a negotiable instrument, writes on the back thereof, pay to Y or order, and signs the instrument. In such a case, Y is deemed to have endorsed the instrument. X is deemed to have endorsed the instrument to Y. So if X delivers the instrument to Y, X ceases to be the holder and Y becomes the holder. So delivery has to be there. Delivery is a very important part of endorsement. So we also saw that what is endorsement in blank and endorsement in full. So in these slides, these are given in a very clear way. So there are various types of endorsement. Particularly, if I say there are 5 types of endorsements. So endorsement in blank, or you can say only signature, where the endorser just puts his signature without specifying the endorsee. The endorsement is said to be a blank endorsement. It means that anyone whosoever is the bearer of this particular instrument, which is having a blank endorsement, can get it encashed from the bank. So the effect of such an endorsement is to render the instrument payable to the bearer, even though originally payable to the order. So if you want to convert any order instrument into bearer instrument, just give a blank endorsement and the instrument will be converted into a order instrument. Okay, a bearer instrument. So if an instrument is a order instrument, it can be converted to a bearer instrument merely by the endorsement by the holder. So whosoever will be the holder has to make an endorsement regarding converting it. So he can just make a blank endorsement, it will be converted. Next is your full endorsement. Full endorsement is when the endorser's signature, when along with the endorser's signature, the name of endorsee is specified. So endorsement is called endorsement in full. Thus, there where the instrument states pay X or order and is signed by A, the payee constitute the endorsement in full. It means that it has been fully endorsed to him. Now this has become a order instrument, not a bearer instrument. So in order to make, so order instrument can be made bearer and bearer instrument can be made order. So in order to make the order instrument a bearer, you have to do a blank endorsement, and in order to make a bearer instrument a order, you have to give a full endorsement or endorsement in full. Next is your partial endorsement. Normally partial endorsement is not valid now, but this is actually this endorsement actually entitles the other person to take only a part of that particular instrument. For example, if the instrument is written for 10,000 and A endorses is to B saying that the pay B or order rupees 5,000. So this is a partial instrument, but it is not valid these days. There is an exception to it, that second part of section 56 states that if the bill has been paid in part, the fact that the part payment may be endorsed on the instrument and it may then be negotiated for the residue. But you have to actually say that how much part of the instrument has been paid. So whosoever has, suppose for example, there was an instrument of 10,000 as given over here, and A has endorsed it to B to the extent of rupees 5,000. Now this endorsement will be not valid if it is endorsed further as such. Now what the thing is, because of the virtue of this particular instrument, B is to receive rupees 5,000, so B must receive 5,000. So if the B has received 5,000, the fact that B has taken rupees 5,000 out of this instrument must be endorsed on the instruments along with the endorsement that 5,000 has been paid. Now this bill is liable only to 5,000. So such type of endorsement is called partial endorsement. Normally such endorsements are not useful these days. Okay. Next is a restrictive endorsement. So as the name suggests, it's a restrictive endorsement. It happens when the endorsers, while making the endorsement, restricts or excludes the right of endorsee to further transfer the instrument. So he is actually restricting the endorsee to make it a bearer instrument. It means that whatever instrument a person is having, it has to be a order instrument, only limited to the you can say only limited to payment by the holder of that instrument at that time. Okay, so this actually constitutes the endorsee as in to endorse the instrument or receive its content for the endorser or some other specified person, but he cannot actually further endorse it, or you can say it prohibits or restricts the further negotiability of the instrument. So it merely entitles the instrument to receive the amount which is there in the instrument itself. Next is your conditional endorsement. Conditional endorsement, according to section 52, gives the power to the endorser to insert a endorsement by express words, a stipulation negating or excluding or limiting his own liability to the holder by making such a liability or right of the endorsee to receive the amount due upon happening of certain specified event. So he has actually put a condition in it and has made the instrument a conditional instrument. So that is a valid instrument, but all the people, those who are getting this instrument, must be made known about the fact that it is a conditional instrument. Otherwise, the other person will be having a right to sue. I have told you before also. Okay, so this is what the thing is. So there are 5 types of endorsement we have gone through. Okay, and now we will be studying the dishonor of the negotiable instrument. Now let us just go for dishonor of a bill. So a bill may be dishonored by first by non-acceptance or second by non-payment. Okay, so bills of exchange is said to be dishonored by non-acceptance in any one of the following ways. That is according to section number 91. When the bill is duly presented for acceptance and a drawee or one of the several drawees, not being the partners, refuse. Now, if they are partners, even if one partner will accept, then it will be called as a due acceptance. But they should not be the partners. But the bill is drawn on multiple drawees at a time. Okay, so a bill can be drawn on various drawees and all drawees have to accept it. Then only the bill will be called acceptance. Now, what happens? That those drawees refuse to accept within 48 hours. So now this 48 hours is very, very important. I can ask you in your, you can say a multiple choice question that what is the time period for this. So 48 hours is the time period for this. So for 48 hours, it has to be, it can be accepted as such. So within 48 hours, it has to be accepted. Okay. Or otherwise, what will happen? The bill is said to be dishonored. So in other words, when the drawee makes a default and acceptance upon being duly required to accept, the bill, then he is not accepting it, then it will be called a dishonor by non-acceptance. Okay. Next is where the drawee is incompetent to contract. So if the drawee is incompetent to contract, again the bill will be said to be dishonored, but the liability in both the case will be different. Okay. Next is when the drawee gives a qualified acceptance. So the holder may treat the instrument as dishonor. So he has given some condition or he has reduced the amount. So in that case, it will also be considered to be dishonor. When the presentment for the acceptance is excused and the bill is not accepted, is said to be, it is also said to be dishonored. Okay, so there are 4 instances when the bill is said to be dishonored by non-acceptance. Also, when the drawee is a fictitious person or after reasonable search cannot be found, the bill may be treated as a dishonored one. The effect of dishonored by non-acceptance is that the holder of the bill can start an action against the drawer and the endorsers and need not wait for the maturity of the bill. Now, what happens? Now the bill has been dishonored by non-acceptance. Now, what will happen? The drawer, who is actually maker, he can file a suit against the other party for the recovery of the money because the other person has not accepted it at all. Had other person been accepting it, then the situation would have been something different. So in that case, the drawer need, because it's the maturity itself is not at all applicable. So there is no need to wait for the maturity of the bill because it has not been accepted at all. Maturity comes into picture only when the bills is accepted. So there is no question of peak maturity. So the date of maturity is also irrelevant. The drawer can start filing a suit against that. Next is dishonor by non-payment. So payment happens when the bill actually matures. So dishonor by non-acceptance happens before maturity for sure, and dishonor by acceptance happens. Dishonor by non-payment happens after the acceptance of the bill and on the due date and on the maturity. So there is no question of maturity over there when the bills are said to be dishonored by non-acceptance, but dishonor by non-payment is on the maturity. So a promissory note, bills of exchange and check is said to be dishonored by non-payment when the maker of the note, acceptor of the bill or drawee of the check makes a default in payment upon being duly required to pay the same. Okay, so dishonor by non-acceptance is given under section 91. Dishonor by non-payment is given under section 92. So again, negotiable instrument is dishonored by non-payment when presentment of the payment is excused and instrument when overdue remains unpaid. So in that case also it will also be called as a dishonor by non-payment. So where the promissory note was sent by a registered post and the party liable refused to receive the post, the bill was said to be dishonored. Further, this dishonor of bills of exchange, if the drawee makes a default in the acceptance, then it can happen. If the presentment is excused and if bill not accepted, drawee is incompetent or acceptance is qualified, then it will be called dishonor by non-acceptance. And dishonor by non-payment happens when the payment of a promissory note, bills of exchange and check in this case, the maker, acceptor and drawee makes a default in the payment, or he doesn't pays the bill on its maturity. So further then comes the notice of the dishonor. So dishonor, I hope you all have understood what is dishonor. So when the negotiable instrument is dishonored, either by non-acceptance or by non-payment, the holder must give a notice of dishonor to the drawer or his previous holder in order to make them liable on the instrument. So first of the thing is that their notice has to be issued. Okay. So if he fails to do so, except in case where a notice of dishonor may be excused, he will forfeit his right of action against prior parties entitled to the notice of the dishonor. So he has to actually, tell the other party that your bill has been dishonored. So this is a must condition, that a notice must be drawn. Okay, in case of and it has to be the person has to be informed. Okay, so if he fails, then what will happen? When the notice of dishonor is excused, he will forfeit his right of action against the prior parties. So all the prior parties will be enjoying, okay, in that case, because he will lose the right of action against them. Next is the object of the notice of the dishonor. Why notice of dishonor is given? So object of the notice of dishonor is to inform or warn the party or the person who is liable on the instrument about the dishonor of the instrument. He must be known. He must know about it. Also, in case of drawer, to enable him to protect himself against the drawee or acceptor who has dishonored the bill. So the notice is necessary. Whatever the nature of the instrument, that is, maybe it may be by sight or by demand or whatsoever, or whether it is accommodation bill. So whatsoever it is, so it has to be actually warn the party. Now what happens again? Why this warning is needed? Because there may be some chance that the person may get a notice of dishonor, and after that he may pay the amount. So there is a chance of getting the payment in that case. Okay, so that's why the notice of dishonor is sometimes necessary, and he must also be ready. So he must look into the matter. Sometimes actually bill get dishonored, and the other party who has actually, the drawee or the payee who has to pay the amount is actually not at all aware about that his bill has been dishonored, and secondly, at the same time, he may not be at fault. So he must actually look into the matter. So that's why this notice is given, so that he may look into the matter, and if it is not by his mistake, or if he is ready to pay, he can pay the amount on the instrument. Further, in order to make the drawer liable on the dishonor by the drawee or the acceptor, it is necessary that a notice of dishonor must be given. So in order to make him liable, in order to, notice of dishonor, suppose dishonor has happened and you have not given any notice. So what it will be assumed? It will be assumed that you do not want to take any action because of the dishonor of the bill. So that's why, again, in order to make the other person liable, you have to inform him, you have to give a notice of dishonor. So the omission on the part, and that's why if notice is not served, it will be deemed that you do not want to take any action. That's why the omission on the part of the holder to give a new notice of the owner would discharge the drawer not only from his liability upon the check, but upon the original debtor consideration also, because not giving a notice, it is deemed that you do not want to take an action. And further, the doctrine of notice of dishonor is based upon the principle of just and equity. So it will be just and equitable to just give a chance to the other person to see into the matter, whether what is wrong with why the bill has not been paid. Okay, so that is the thing. So this is given in the nutshell, that if promissory note, bills of exchange, check is dishonored by acceptance or non-payment, the holder or some party thereto liable thereon give a notice of dishonor to the parties whom holder seeks liable. And this such notice can be severally or severally or separately to each party and jointly to all of them. Okay. So by whom the notice should be given? That is given under section 93. So notice by whom? Notice of the dishonor must be given by the holder or by a person liable on the instrument, but it is not necessary that notice should always emanate from the holder, or he is entitled to avail himself for a notice given by any party liable on the instrument. So notice of dishonor given by a stranger is of no effect, because Strangers is nothing to do with it. Okay, even a notice given by a party to the instrument is not valid if at the time of giving such notice he is not liable thereon. So any person who is not liability, so a person who who is liable and whose against whose the liability is to be created. So notice has to be served from this person to that person. Further notice to whom. So by whom you I think you are able to understand. And notice to whom it is given. Notice of dishonor must be given to all the parties other than the maker or acceptor or the drawee whom the holder seeks to make liable. Okay. So notice of dishonor, because he themselves will be giving it. So notice of dishonor to the acceptor of the bill or to the maker of a note or a drawee of the check is not necessary, because he himself knows that he has been it has been dishonor, because whenever dishonor happens, they know that the dishonor is happening until unless there are some technical faults. So they are the parties primarily liable upon the instrument on the due date and the proper place. It is they who dishonor the instrument by non-acceptance or non-payment. The notice to them will merely be a notice of the fact already known to them. So that's why a notice may not be given to that particular person, but to other person. Suppose a payee is there, so suppose a third party is there to whom, or some endorsees are there to whom it is, then in that case the notice will be given. Or suppose I have taken a bill from someone else, and that bill is to be, was accepted by the third party. So the party from whom I have taken the bill, he must be informed that the bill has been dishonored. The party who has dishonored the bill, he always know it that the bill has been dishonored. Okay. So now what can be the modes of giving the notice? So notice of the dishonor may be given to a duly authorized agent of a person to whom it is required to be given, or where he has died, to his legal representative, or where he has been declared insolvent, to the assignee, or it may be oral or written. May, if written, be sent by post and may be in form, but it must inform the party to whom it is given, either in express term or by reasonable intendment, that the instrument has been dishonored, and what what way, and that he will be held liable thereon, and it must be given within reasonable time after dishonor at a place of the business. In case of such party is no place, at the residence of the party whom it is intended. So this particular line is a one line, complete one line, and this is very complicated to just read it once and understand it. So if you just read it in parts, then you will be able to understand that modes of giving notice, number one, can be oral or it can be written. Number one point is this. Okay, so it can be either oral or it can be written, but I recommend that it has to be in writing, because you need a evidence to be presented in the court that you have given the notice. Okay, or otherwise, if orally it is done, you have sufficient proof to showcase or to understand or to make the court understand that you have actually given the notice. That's why mostly the things which are oral are discouraged. Okay, so number one is this. So notice of dishonor may be given to a number one, to a duly authorized agent of that person. So when the agent receives the notice, it is deemed that the principal has received it, because agent work on the behalf of the principal. So and agent bind principal by all his acts. So it can be given to any of the authorized agent. Okay. Further, where the person to whom the notice given has died, then it should be given to his legal representative. And if he has been declared as insolvent, it can be given to the assignee. Okay. And such thing can be done in oral, written. I have already told you it can be sent by post or by any form. But it must inform the party. More important thing is the information of the party to whom it is given, and it can be either express or by reasonable intendment, means it can be express or implied, and such instrument has been dishonor, and in the way, because you have to inform that the instrument has been dishonor, and it can be in any of the way. The main criteria is that the person must be informed that the instrument has been dishonor. Next, the party receiving must transmit the notice of dishonor. So any party receiving the notice of dishonor must, in order to render any other party liable to himself, give a notice of dishonor to such party within a reasonable time. Suppose A has taken bill from B and B has taken bill from C and C has taken bill from D. and the bill has got dishonor. So A has to inform the B, and B must inform the things to C, and C must inform it to D. Okay, so A must not inform to D. Why? Because D has made a default, or someone else has made a default, he knows, and he has actually given it to D. So in that case, the proper parties from whom you have received the bill must be informed well in time. Okay, so such notice must be, in order to render any prior party liable to himself, give a notice of dishonor to such party within a reasonable time, unless such party otherwise receives due notice as provided under section 93. So if the notice has been provided under section 93, then it is okay. If it is not, then it has to be given within a reasonable time. Thus, a person receiving the notice must transmit it to the prior party. I've just now given you the example, to whom he wishes to make liable to himself, because the holder may have omitted to give notice to some of the prior, because he will give, because A has taken it from B has taken it from C. So A may not be knowing who is C. Okay, his name may be endorsed, but why he will give notice? Because he wants to make only B liable, क्योंकि B से ही पैसा मांगता है, तो B will only be made liable in that case. Okay, so he may file a notice only to B. So it's a duty of B that he should file a notice to C, and C's duty is to file a notice to D. So when notice of dishonor is unnecessary, so no notice of dishonor is unnecessary. Number one, waiver when it is dispensed with by the party entitled thereto. A waiver of the notice may be made at the time of drawing or endorsing the instrument, or before after a time for giving the notice has arrived. So a waiver by a party to receive the notice ensures for the benefit of all the parties coming after him. Next is, no notice of dishonor is necessary in order to charge the drawer when he is countermanded the payment, because he has actually countermanded the payment, he has actually not made the payment. So he himself knows that I have not made the payment, so no notice is required. No damage. When the party is charged could not suffer damage by want of the notice, so then there is no need of giving the notice. Okay, so the parties who intended to be affected should be given notice properly. So when the parties entitled to notice cannot after a due search be found, or the party is bound to give notice for any other reason, unable without any fault of his own to give. Now here comes a loophole, because when you are not able to find the party, or parties cannot be found, so here what people do, they just dishonor the thing and they vanish, they abscond. Okay, so till they are absconding, they have not received the notice. Until unless notice is received, you cannot proceed further with your inquiry and other things. So Vijay Mallya also absconded himself for a very long time, because so that he should not receive any notice. Okay, next is to charge the drawers when the acceptor is also a drawer. So in such case also you need not to give a notice. And last is in the case of promissory note, which is negotiable, because promissory note itself has only two parties. That's why, and it is not negotiable. So it is between the two parties only. There also notice is not required. Next comes the noting and protest. Yeah, before we proceed further with noting and protest, if you have any problem, you can ask me over here. Come on. Any problem? If you want to ask any question. This was merely regarding the notice. Next is your noting and protest. So noting is given under section 99. So you can remember this. I remembered it this way. 99 no noting. Okay. So no matlab noting. So 99 is the section for noting. So when a promissory note of bills of exchange has been dishonored by non-acceptance or non-payment, the holder may cause such dishonor to be noted by a notary public upon the instrument, or upon a paper attached thereto, or a party upon each. Now what happens? What actually is noting? This notary public person is a person from the government. He is appointed by the government in order to make the notations. So notary public notes each and everything, and actually he has to certify it that yes, it has been dishonored. Okay. So whatever has happened, whether it is a non-payment or non-acceptance, the holder may cause such dishonor to be noted by a notary public, and it has to be done on the instrument also and in his notebook also, which he is maintaining. Okay, so such note must be made within a reasonable time after the dishonor and must specify the date of the dishonor and the reason, if any, assigned for such dishonor. Or if the instrument has not been expressly dishonored, the reason why the holder treats it as a dishonored, and then and he has to pay some notary charges also for it. Okay. Further, noting must contain the following particulars: the fact of the dishonor, as we have just now seen. Okay, it must contain the fact of the dishonor. Next is the date of the dishonor, the reasons. If the instrument has not been expressly dishonored, the reason why the holder treats it as dishonor, and notary's charges whatsoever. Noting must be made by a notary within a reasonable time after the dishonor, and noting is not compulsory in case of an inland bill or note. The omission to get the instrument noted does not in any way affect the rights of the holder thereon. Noting is, however, compulsory in case of foreign bills. So in case of Indian bills also it is not required, but it is always good to have noting done. Why? Because noting actually authenticates, because this notary public will call that person and will ask, are you able to pay or not? I am just noting this bill as a dishonor, and it will be because a person who wants to file a suit against someone will definitely go for a noting because it is a legal process. Okay, next is your protest. So noting is 99, protest is 100. So when the promissory note or bills of exchange has been dishonored by non-acceptance or non-payment, the holder may within a reasonable time cause such dishonor to be noted and certified by a notary public. Such certificate is called protest. Okay, so protesting is a certificate which you receive after getting the things noted. So merely noting and not taking certificate is not a valid one. So when we are going to get it noted, then you have to take a certificate of such. So protest, what is a protest? Protest is a certificate issued by notary public regarding the dishonor of a bill. So content, what are the content of the protest? Protest is based on the noting. A protest, in order to be valid, must contain all the following particulars. What are these? The instrument itself, or later, just a moment. These things should not come like this. Yeah. Now it is okay, I suppose. Just a moment, guys. Yes. Okay. Second is the name, and the first is the instrument itself, or a literal transcript of the instrument and of everything written on printed thereupon has to be a part of it. The name of person whom and against whom the instrument has been protested. Next is the fact and the reasons of the dishonor, that why it has been done. Okay, and what are the reasons of, sometimes signatures do not match, sometimes the holder is not there, sometimes it is there that he may not be having money. So whatsoever are the reasons have to be mentioned. So notary public may make a demand either in a person or his clerk, or where the authorized by the agreement or usage by the registered letter. So he will issue a registered letter. The place and the time of dishonor. Okay. The subscription, that is a signature of the notary public, has to be there. Seal has to be there. So in case of acceptance for owner or payment for owner, the name of the person accepting or paying the name of the person. Now what happens? Suppose the instrument has get dishonored. So what will happen? The person who wants to get it honored, so somebody else will honor it on behalf of that person. So he will pay the amount of that particular person, and that also has to be noted in the protest statement, because now the protest statement will be the person who has honored the bill for so who has accepted the bill for honor, or you can say who has paid the bill for honor. So there is a difference between noting and protesting. So you can just see the difference that there is not that much, but actually one actually is dependent on the other one. Okay, so these are the differences between the notice and protest. And again, the protest notice has also to be is also required to be given. So when a promissory note of bills of exchange is required by law to be protested, notice of such protest must be given instead of notice of dishonor in the same manner and is subject to same condition, but the notice may be given by the notary public who actually makes the protest. So this notice will be given by the notary public. So protest for non-payment after dishonor or non-acceptance, all the bills of exchange drawn payable at some other place than the place mentioned as residence of the drawee and which are dishonored by non-acceptance may, without further presentment to the drawee, be protested for non-payment in place specified for the payment unless paid before the maturity. Sometimes these acceptors they just change their place of business. So if the change in place of business also makes the bills dishonor. Okay, so in that case, what they can do is they can either get the payment well in advance, or you can say they can change the date of payment and on not date, the place of payment, and on the designated place of payment they can make the payment in order to save themselves from this protest. Foreign bills are also to be protested. Okay, so foreign bills of exchange must be protested for dishonor when such protest is required by the law of the place where they are drawn. So such foreign bills must be protested as a law of most of the countries have made a protest compulsory in case of dishonor of the bill. So according to that particular country, whatever are the laws, they are to be applied, and accordingly the protest will happen. So this is all about today. Tomorrow we will continue with the crossing of checks. This is the last topic in your syllabus. Any question?
No, sir.
Okay, so I'm just taking the attendance so that we can. Yeah. So again, attendance at the end of the class. Drishti Verma, Harshit, please say yes, sir. Yeah.
Present, sir.
Harshit Kumawat, Hemant Kumar,
Present,
Present, sir.
Yes, sir.
Kartikeyan Sharma,
Yes, sir.
Khushi Shekhawat, Laksharaj Singh, Lakshya Raj
Yes,
Singh,
sir.
Yes, sir.
Nandini Khandelwal, Parth Narendra Bhai, Prakash Chaudhary, Puneet Yadav, Pushpendra Pal Singh,
Yes, sir.
Rahul Jaivaria,
Present,
Rakesh
sir.
Raika, Ravi
Present,
Kumar,
sir.
Rohan
Present,
Modi,
sir. Present, sir.
Shaurya Dikshit, Soumya Deepa,
Present, sir.
Sarosh,
Present, sir.
Tirtha Kirti Bhai.
Present, sir.
Okay. Fine then, guys. Take care. Have a nice day. Bye bye. See you.
Bye, sir. Bye.
Take
Bye,
care.
sir. Thank you, sir.
Bye.